Hello everyone, welcome to Law with Ease. Today we'll see stay of execution as laid under Order 21 Rule 26 of the Civil Procedure Code. It says the executing court, if sufficient cause is shown to it, then it can stay the execution of the decree and it will enable the judgment debtor to apply where to the court which passed the decree or the appellate court for an order staying the execution of the decree, and the court must also require security to be deposited or impose such conditions upon the judgment debtor before allowing the stay of execution. Now let's go further to modes of execution. Order 21 Rule 30 to 36 lay down the modes of execution of various types of decrees. Firstly, Rule 30, which says decree is for payment of money. Also, it includes payment of money in alternative of the relief. How is it executed? Detention of the judgment debtor in civil prison or attachment and sale of his property or both. Likewise, Rule 31 says decree for a specific movable property or for a share in a specific movable property. So how it is executed? By seizure if practicable, also by delivery to the decree holder, or detention of judgment debtor in civil prison, or attachment of property of the judgment debtor, or by both detention and attachment. If there is attachment and such attachment has remained in force for 3 months, then there are two courses open. Judgment debtor has obeyed the decree and he has not obeyed the decree. Where he has not obeyed the decree, then the decree holder can apply for sale of the attached property and court may award the decree holder out of the sale proceeds. Also, where judgment debtor has obeyed the decree or the attachment period of 3 months ends or no application has been made by the decree holder for sale, then the attachment comes to an end. Then Rule 32. If the decree is for restitution of conjugal rights, then the against party or the party against whom the decree has been made has willfully disobeyed it. Then the decree may be enforced by attachment of the property. If the decree passed against a person for specific performance of contract or injunction, then the party against whom it has been passed willfully fails to obey it, although he had an opportunity to obey it, then decree may be enforced by his detention in civil prison or attachment or both. Further, court also may order the act to be done by the decree holder at the cost of the judgment debtor. Then Rule 33. If the decree for restitution of conjugal rights is against the husband and husband does not comply with the decree within such prescribed time, then he shall make periodical payments to the wife of amounts fixed by the court. Then amounts and intervals to be varied or modified by the court, and it must be recovered by the wife as if they were payable under a decree for payment of money. It is simplified as such. Then Rule 34. If the decree for execution of a document or is for endorsement of negotiable instrument, then the judgment debtor neglects or refuses to obey the decree. So the decree holder may prepare a draft of the documents or endorsement. Then it will submit to the court. Then the draft then be served on the judgment debtor. Then the judgment debtor's objections will be considered and the draft is incorporated on a proper stamp paper. If the decree is for delivery of immovable property as laid under Rule 35 and the possession of such property is to be delivered to the decree holder, then any person if refuses to vacate, he may be removed. And if the decree for joint possession of immutable property is under Rule 35, then the possession shall be delivered. How? By affixture in conspicuous place or by beating of drums. Rule 36 lays the decree for delivery of immutable property when in occupancy of tenant. The process is same as in case of decree for joint possession of immutable property. So this is all about stay of execution and mode of execution under CPC. Hope you all will like it. Please like and subscribe. Thank you.